Fire Away tackles burning questions and hot topics in Canadian employment law, human resources, and dispute resolution. Hosted by Rudner Law, Fire Away is your go-to source for legal insight on the world of work. So whether you are an employee or an employer, a lawyer or an HR pro, let's ignite the conversation and get into today's episode. Here's your host, employment lawyer, mediator, and founder of Rudner Law, Stuart Rudner.
Welcome to Season 7, Episode 8 of Fire Away. Today, I'm very excited to be joined by Peter Cusimano, who's a Toronto business lawyer I've known and collaborated with for many years, and we're going to take a bit of a deep dive into some of the HR issues that arise when you're either starting, buying, or selling a business. Peter, welcome to the show.
Thank you for having me, Stuart.
Really looking forward to the conversation. It's obviously a continuation of a conversation that you and I have on a pretty regular basis, and I think we've done some great work collaborating with clients and where they understand the need to have a team as opposed to just one advisor or one lawyer. And the timing of this is perfect because just a couple of days ago, I met with a new client, and I'm going to change some of the facts just to protect the innocent, as they say. But basically, the situation is that they're a fairly young, unsophisticated person, not in the business world, and they had the opportunity to buy a business. And I'll change it to be a bookstore. Imagine you've got a relatively young person, spends all their time or all their free time at this local bookstore. They get to know the owner, they know the staff, they become almost one of the family. And then at some point, the owner mentions that they're looking to retire and sell. And then they start talking about what it might look like if this person buys the business. And they talk about the usual things, mostly what the price is going to be. And then all of a sudden, they've bought the business and now they're a business owner. And then they realize that they're an employer. And then they realize that all of their friends, who are the staff, have their own issues. And as the business owner and employer, they've got to deal with it. But she's never even looked at contracts or policies or anything like this. So unfortunately, this is, as you know, this is not an unusual case, but from your perspective as a business lawyer, what would you want that person to know from an HR perspective and otherwise before they got into a deal like that?
So that's actually a very common issue, Stuart, and I see that come across my desk many times. And so usually what happens is either the seller or the buyer, they don't pay adequate attention. And what's going to happen is exactly the scenario which you've discovered here or you're describing here, it will come up. So when I'm acting either for a buyer or a seller, one of the first things I do look at is the HR issues. In particular, I want to see who are the employees? Do you have employment agreements? How long have they been working for the company? What are their roles? What are their what's their duties and roles? Sorry, and also how much are they being paid? And all these will come into factors that we have to look at, because if you are a buyer, what a lot of times buyers don't realize is that when they take on employees and when they buy a business, what's going to happen is they're inheriting all the past legacy history of that employee. So if that employee's been with that bookstore for 20 years, and they may be a great employee, or maybe they're not. But when a buyer buys a business, they are inheriting 20 years worth of history with that employee. And so that could be a problem. If it's, even if it's not a problem at the time of the purchase, it could be a problem 6 months or a year or 5 years when something goes wrong, or the person, you decide to scale down, or you don't like that person, or you want to change their roles. So these are things that really need to be taken into account. And we get it usually that owners or buyers and sellers are so busy worrying about everything else, but they pay not enough attention to the the employee issues is what they're not paying attention. So in that aspect, I usually do raise it, and that's likely where problems may arise, where people realize, oh, we don't have employment agreements. Oh, what? It's going to cost us this amount to terminate this employee. So these are factors that need to be considered.
Yeah, and you kind of you stole my thunder a little bit when as you know, I like to do a bit of a rant at the end, and that was going to be one of my key points, is they're often so focused on everything else, they don't even turn their minds to these issues until the day of the deal or many months later at times. So one of the questions, when I was consulted by this new client the other day, one of the questions that I asked is, when you bought the business, was it a share purchase or an asset purchase? And you understand this stuff better than I do. Maybe you could briefly explain what the difference is, and in particular, how that impacts the employment relationships.
So when you have a purchase, what a share purchase means is the company, you're actually going to buy the company. The company is owned by shareholders, and you can go in there and you can actually purchase the shares. So the actual business is the same, it's just the owners have changed. So there's no change in the employee agreements, there's no change in any of those things, everything remains the same. However, what happens is you are inheriting everything there, especially when it comes to the employees. When you do an asset purchase, that's slightly different. So instead of actually buying the shares of the company, you are buying particular assets. So for example, in a bookstore, you're going to buy all the inventory, you're going to buy the shelves, but you're also going to buy or take on the lease, and you're going to take on all the employment agreements if you want. Otherwise, what's going to have to happen there is essentially there's a termination, and then you have to hire the new employees. The purchaser has to hire the new employees on the same terms and conditions. And so you do run into a little bit of issues. Some employees may not want to continue on. Or if the purchaser wants to change the terms, maybe they want to change the salary or do something different, there's going to be issues that arise simply because of the way the employment law is set up in Ontario, that the purchaser has to be really careful what they're doing when they're acquiring by way of assets.
Yeah, and I think it's an important distinction because as you said, if it's a share purchase, you're buying the business, and as I often explain to people, basically what that means is that the owner of the business might change, but the business is still the employer. That hasn't changed. So you worked for ABC Company last week, you still work for ABC Company. Whereas, as you said, if it's an asset purchase, it's no longer ABC Company, it's XYZ Company. And I think what's important, and maybe you can take me through how you advise clients, let's say for the moment that we're talking about a buyer, if it's going to be an asset purchase, what's the conversation you usually have with them about employees and, what their options might be?
So if it's a buyer, what we're looking is, first thing I want to know is I want the buyer to study the employees and determine, can you get along with these employees? Do you want these employees? And look, in some cases, maybe you don't. So in a bookstore, maybe you want to have all the same customer service people, but it could be in a different business. Let's say your spouse you're going to bring your spouse in to actually do the business. So maybe you want to buy a restaurant and your spouse might be a chef. And so you don't want that chef that's there currently. You're going to replace that chef with your own chef. It makes total sense from a business point of view. But you have to think about this because now I say to people, okay, if you're the buyer, somebody has to pay for the termination of the existing employee that you no longer want. And usually you're going to get resistance from the seller. Now, if you're the seller, you have to take this into account well ahead before you sell the business, because this will come up. And then now, usually what a compromise is often reached for. So what happens is the buyer will take on all the employees on the same terms and conditions. And we usually put like a situation where it says, we'll try them out for 3 months, let's say. And at the end of 3 months, the buyer wants to terminate someone, then what we have is some type of arrangement that's negotiated between the buyer and seller, where either the seller is going to pay for the termination of that employee, or some combination of you're going to split the liability or the expense that's involved. But clearly this is where planning is involved. And oftentimes, because employment issues are emotional a lot of times, and it becomes something that really needs to be carefully thought about. And it's a combination of legal, and you got to speak to your accountant about what the financial implications are, and even just sort of from a personnel perspective, do you want these employees, or some of them are maybe, they have different personality styles. And so it's something that needs to be really thought out right from the beginning of when you're either buying or selling.
Yeah, which again gets back to your point of not ignoring this issue until the very last minute, which unfortunately happens a lot. But there's a lot of options, and whether it's a share purchase or an asset purchase. I mean, as you know, I often say there's two different negotiations that should happen. The buyer and the seller should negotiate how they're going to deal with potential severance issues. And then the buyer has got to negotiate with the staff, because they 99 times out of 100 should put in new contracts in place, because the contracts that are there are probably not going to protect them properly. And in fact, if it's an asset purchase, as you explained, it's a new employment relationship. So you need new contracts. So all those things should be done. And like you said, if you negotiate things in advance, you can agree between the buyer and seller as to who's going to be on the hook for severance. And as you know, there's dozens of different ways to do this, but you can have, usually the buyer will have some time to try out the employees and then decide who they're keeping, and then they can have some formula for who's on the hook for severance. So I want to flip the perspective for a second. If you're advising the seller, and I love sharing some of the war stories. So one that I saw, and of course I don't see nearly as many of these as you, because in many cases parties don't involve employment lawyers. They might involve a business lawyer, but then they don't get employment lawyers involved at all. But I remember one that I saw that fortunately we got involved early, because in that case, what happened is the potential seller owned a fairly successful business in downtown Toronto, and it was an older couple, and they were looking to retire and sell out. So they were going to sell, but what became clear to me was that the buyer just wanted the land. Right, this was downtown Toronto. They were going to knock down whatever the building was and make it a parking lot. Sounds kind of like a song, but anyways, they're going to make a parking lot out of this. So clearly, none of these employees were going to be kept on because they didn't need them. And so when I sat down with this couple who were going to be the ones selling their business, and I explained to them that they were going to effectively be terminating all of their employees. And then, of course, they didn't have good contracts in place, so there was no limit on severance. When we started doing the math as to what these severance costs would have been, it reduced their potential profit by about 40%.
Right, that's a good point, Stuart. That's a very
and like I said, in that case, because we got involved early, they were able to go and they didn't have a deal in place. They had a tentative deal. So we were able to recover. But sometimes it's too late.
What also happens sometimes on a sale is that employees, they'll figure it out. They'll determine that, or they'll find out that there is a pending sale. So sometimes they're worried. And so what they'll do is the employees will think, oh, I have to now start looking for another job. And so from a seller perspective, we want to make sure that the employees are comfortable, they're reassured, and this does require good communications and coordinations between the buyer and the seller to have a smooth transition, because the buyer sometimes is looking to maintain the employees. So in that scenario, if all of a sudden half your employees decide that they're going to go get a new job because they thought that that's the end of it, because either their boss is retiring, and so the value part of it is in the employees. So this could affect even the value of the business, especially if some of them are key employees. And so that's something as a factor that needs to be thought out.
Yeah, that's a great point. And just I want to come back to the issue of, sometimes the buyer wants the seller to stick around for a period of time. So I want to come back to that. But you made a really interesting point. What if you're buying the business and there is a key person in place, and the buyer wants to make sure that person stays, and they're not the seller, so they're not an owner? How would you address that type of thing?
So there's it's both legal and non-legal. So on the legal side, what happens is we can put into, basically what happens is the buyer will hire the seller as either could be a consultant. So, or they could hire them depending on what the nature of what they're doing, they could hire them as an employee and stay on for a while if they want. Usually what it is, though, is what I found from a practical perspective is the buyer wants the seller to stay on just so they can learn the business, the nuances, and figure things out. But what I found is after a while, a lot of times what happens is the seller who now is an employee, they don't have control anymore. So now they're no longer the boss. And so sometimes what happens is there becomes tension between the new owner, who's the new boss, and the seller, who's now an employee. And so oftentimes what they'll do is a few months later, I get a call from the buyer, if I represented the buyer, and they'll say, listen, I don't need this person anymore. I now want to terminate them. So these are things that have to be thought out at the time of the transaction and also put into place. What exactly do you want the owner who's staying on? And what you also don't want to happen is you want to put something in an agreement that basically says that if that owner decides to once they leave, if whether it's right at the closing or if they're staying on for 6 months, let's say, what will happen is you want to make sure that that owner then doesn't get anxious and decide, well, I want to get back into business, and then
Right.
they can just take all the existing clientele, or they know everything about the business that they just sold. So it's very risky in the sense that they could come back and just open up a competitive business right across the street, take all your clients, and they know all the ins and outs. So these are things that I usually tell the buyer to be especially careful with. And if I'm the seller, I usually tell them, listen, you're going to have to do this in order to sell the business. So the best thing you can do is to help out the buyer so they don't have regrets or come in later afterwards and complain that what they bought wasn't what they thought they bought.
Right. Yeah. And to your earlier point about, the seller not going and starting a competing business, of course, you can have a non-compete agreement and that kind of thing. And I think that's one thing I was going to highlight, because I often comment on the fact that non-competition clauses are not enforceable in Ontario or in Canada. I'd say that's 99% of the time. But we're talking about that in the context of an employee. If you're talking about someone who sold a business, completely different. And as long as the terms are reasonable, courts will enforce a non-competition clause against someone who was paid money to sell their business.
Yes. It goes a little further than that, Stuart. If you have, let's say, a business where somebody is creative. So let's say you have a website design business, and you have a programmer who knows how to do nice graphics and everything. Well, what some people don't realize is that graphic person who did that creative work, they actually have inherent rights into the work under the Copyright Act. So these are things that need to be thought out. And when you're selling the business, even when you're running the business, you need to think about these things. Those would go into an employment agreement, but especially on a sale of a business, you need to look at what's called the intellectual property and make sure that that you're acquiring it as the purchaser, and that intellectual property, you don't want any of the employees to have it, because once they leave, they do retain some of those rights if a person's not careful.
Right. No, that's a great point. And it brings me back to what I wanted to talk about was, let's say you're the buyer and you're not so concerned about having the seller stick around, but you want a key person. Let's say, Peter, if you decided that you now want to make sure that your firm does employment law as well. So you decide you're going to buy Rudner Law, but you don't really care about me. You want one of my superstar associates. So how would you protect yourself and make sure that you don't buy Rudner Law and end up just stuck with Rudner and nobody else? How would you deal with that?
Well, in your case, Stuart, just you yourself would be pretty cool, but you have some amazing lawyers on your team and staff members, so you're correct. I would want to take all of them, and so I would put that right in it'd be part of the agreement. And what would end up happening is sometimes you can put in a provision that if an employee leaves, then we're going to reduce the value of or just the purchase price. So one of the things we want to do, this goes back to, as a purchaser, I want to look to see what the agreements that are there, because I want to keep those key employees. So maybe what I'll do is, part of that is you deal with that sort of by making sure there's a good smooth transition, and you have like an introduction, and that sort of, this is where we coordinate and try and help out and suggest, make sure you meet with them right on the closing date, you have the seller be assured that this buyer is a good person. And then you do want to have a new agreement is a good idea. And obviously there's some technicalities on how to go about doing that, but that then just shows that everybody's part of the team. And then, so that's what I would do to reassure everybody. I'd probably give everyone a little bit of a bonus, something like that, just to make sure everybody's on board, everybody's happy. And it's sort of more than legal, like just general human resource type concepts and best practices. It's things that it's like need to be thought out carefully on that.
Yeah, it's a great point, and as you've said a few times, and I say this to clients all the time as well. I mean, there's the legal and then the practical or the business or whatever you want to call it, and that's really important here. And your example of giving the employees a signing bonus is great. A, because hopefully it engenders some goodwill, but B, as you well know, if you have someone who's already employed and you want them to sign a new contract, you usually have to give them some consideration, or in other words, something of value. So if you want the contract to be enforceable, you might have to give them some sort of signing bonus. So it really achieves a whole bunch of purposes in addition to just making them happy and want to stay and work with you. So I think that's a really important point, and it also just comes down to communication, like we always say.
Right. One of the things, look, we get it that as lawyers, the clients are busy and they have limited resources and they got to focus on different things, right? So what we want is, at the end of the day, we want to make sure that the business owner does what they know best, and that's run the business. We don't want them actually worrying all the time about, well, what's going to happen if my employee steals something? What happens if this happens, right? So we want to, ideally, we want to tell them, look, you focus on the business end of things. Take our advice. You know, it doesn't have to, they don't have to go all in, but what they need to do is pay some attention and do some, make sure they do what's reasonable. And so that way, they don't have problems, because as you know, Stuart, when problems occur, especially today, a lot of employees, they know they have rights. They may not know exactly what they are, but they know they have rights. And so, they're entitled to those, but it's very important as the employer that they think these through, because it's going to cost them 10 times or 20 times more to fix the problem down the road than if they just sort of, just put a little bit of time and effort right at the beginning, whether it's starting the business or whether they're buying the business, right? Even if you're selling the business, we tell people, listen, what I tell people is, you got to come to me well in advance so we can look at your employment issues. And if there are any problems, we want to try and address these now, because they will come up eventually. And we're just trying to make it as smooth as possible, so that way the let's say a buyer can focus on their new business, or the seller, they can just move on and not worry about somebody coming back and just sort of filing a lawsuit against them for something related to the HR issues.
Yeah, no, look, obviously you and I work from the same playbook. We always, make that comment that it's going to cost you a lot less to prevent the problem than it will to fix it later. So I think it might be helpful. I'm mindful of time, but I think it might be helpful if you could take people, at least at a high level, through your process. Let's say you're approached by someone who's buying a business or selling a business, and let's assume they've come to you with a reasonable amount of time before they want to close. What's the process you go through in terms of, what do you do and when, and who else do you want to get involved in as part of the team?
Okay, so what I want to do is, I want to first thing get as much detail about the business as I possibly can. And then I want to look at to see if there was, let's say, an evaluation reports or some type of appraisals, because I'll have details in there. And then what I want to do is I want to ask the buyer, what do you know about this business? What do you know about the people there? And they may know little, they may know a lot. I don't know. We're just going to find that out. And then eventually what I want to do is what's called due diligence. And what I'll do is we'll ask, what that means is we're going to ask for copies of details about all the employees to be disclosed, and we want to see it. I'm going to go through all the employment agreements to see if there's any what I consider red flags. And so then, like for example, I want to know if there are any problems with the employees. I want to know if somebody does not have an employment agreement, I need more details. And the reason why I want to know that is because if somebody's just there 6 months and let's say it's a clerical staff, maybe it's low risk. But if you have somebody who's been there for 30 years and they're dealing with they have like managerial type roles, or they're dealing with high responsibility and there's no written employment agreement, that would be almost like what I call a yellow flag, where I then need to get to the client and say, okay, here's some issues like that, and I've got to identify that. And then at that point is I'm going to say, all right, I think we need to bring in somebody with more expertise in this area, such as yourself, Stuart, to actually look at this. I mean, at the end of the day, this is all risk allocation. So some clients may
Right.
not care. Some clients are really worried, and usually they're worried because they're surprised to find out these things. And then I've had transactions end simply because the employment issues could not be resolved. And so I'm looking at this, and hopefully, what we'll do is nothing's perfect. So what we'll do is we're going to look at each of those employees, and then I'm going to go through with the client. And is this an issue? Do you want to keep this person? Do you want to try them out? What do you want to do? And then it's up to them, really. And then we'll work with that. And then what happens from that, we'll frame an issue. So it could be, for example, well, this could be a problem. Maybe I may not like this person in 3 months. So if we don't want to terminate them now, maybe what I'll do is I'll tell the buyer what we're going to do is when we do the purchase, we're not going to turn over all the money. We're going to do what's called a holdback. We're going to keep some of the money back. So in case there is a termination issue, we have money that we're holding back that we can use to apply to pay the termination. Hopefully none of that comes up. And then what we're going to do is we're going to have a written employment, new agreements in place, just sort of to cater to some of the issues we talked about earlier. And then what will happen is when it comes to the closing date, I'm going to tell them, let's have a meeting, and then to make sure it's good introductions. And then I'll follow up with them maybe 2 weeks afterwards, and then a month afterwards, and see how are things going, not just on, the employment issues, but the whole business. But I'm particularly interested to know if there's any employment issues, because if there are, this is where we're going to find out. And it could be a personality clash. And so hopefully there's not a problem. And then, if there is, though, that's where then I would then have to examine it. And most likely in that scenario, that's where we have to refer it to someone like yourself who has, or one of your colleagues that has expertise right in this area here, who then, that way, because we're looking for, more expertise advice.
Right. So I'm curious because I'm not so naive that I think that there's an employment lawyer involved in every deal. And I know from speaking to you and many of your colleagues that in many cases there aren't. And in many cases it's because the client says, I don't want more lawyers. I can't afford more lawyers. You're the lawyer, you handle it. So I'm curious as to, if I guess it's the same whether you're working with a buyer or a seller, and you get that objection. What would you tell them, or how would you explain to them the risks of going ahead without getting advice from an employment lawyer?
So I understand how they feel. I get it. I'm a business person myself, just operating my own law practice. So I get it. What I found from experience is, though, I would tell them that, listen, it comes down to risk allocation, and you're taking a big risk here. And so what I try and tell them is to say, listen, what I can do is I try to be, the analogy I use, it's almost like it's like you go to your family doctor, right? And then what happens is they can figure, oh, look, you got a little murmur in your heart, but they can't really tell you anything beyond that. But they're smart enough to know, I've got to refer you over to someone else. It doesn't mean you're going to have to break the bank. What it means is even just a consultation to take a look. Is there a problem here? Right? Is this something we need to think now and plan now before this thing really gets up there? So usually what I tell clients is, why don't you just give me authorization to phone Stuart yourself, and then I'll give you the facts, and then right. So it's not a large time commitment, but the benefit is much better. And then at that point, that's just a small investment that the client has to pay. And then if there is a problem, then okay, then I'll recommend we need to, look further on this, or maybe it can be resolved much simpler. So I tell clients, listen, look at it that way. But you're right. I mean, sometimes they, at the end of the day, like if the client says no, they don't want to do that. As long as they understand what the risks are, but I find that they underestimate the risk often.
Yeah, well, I think they always do, and that's just human nature. But I think it sounds like you do a pretty good job of explaining exactly what we keep saying, which is it's going to cost you less money to avoid the problem or prevent the problem than it will cost you to fix the problem later on. So, we all go through this, right? We all work with our clients, and we all recognize that there are legal issues and business issues. So they make the decision at the end of the day. As long as, my view is, as long as you let them know what the risks are, make sure they make an educated decision, then that's, you've done your job at that point.
What I found, just a quick point here, is that for those clients who actually for the most part, they take my advice and they will go along with that and follow up with yourself, Stuart. And what I found in every case where the client, then I always sort of come back and I say, okay, well, if I'm not part of it, that consultation, because I'm there usually with the client when I consult with you, Stuart, let's say. And
Yeah, no, you're great. I've had some lawyers who often just kind of pass clients off to me, but you're great at always being involved. And I think clients really appreciate that.
they do. The reason why I do that also is that because what I always find is they can get feedback from the clients and they always say the same thing. Wow, I'm so happy I went and I took that extra step because I didn't realize that it was so complicated, or I didn't, I wouldn't have been able to navigate, is what they say, this issue themselves. And boy, it's just saved a lot of time. They invested a little bit, and then now all of a sudden they want to, hopefully then at that point, then they're like they want to change their business to really get everything lined up once they realize how serious the situation could be, right? And it's sort of preventative medicine. That's how I see it as.
Yeah, no, I think we take a similar approach. We both like to be proactive and preventative. So we've take a look at the time. We've covered a lot. We didn't even get to starting a business, closing a business, or all the other things we talking about. So we'll have to have you back at some point. But before I take my turn to fire away, I did want to give you a chance, Peter, just to let people know how to find you if they'd like to speak with you.
So the best way is to you can go on the internet, just go to Cusimano.law, and that's CUSIMANO.law. And then you'll find I have some videos there, some resources, my contact information is there, and anybody wants to give me a quick call, I'd be glad to talk to them for a few minutes, and then if it's something more serious, then obviously then I'll just refer them right over to you, Stuart, and which is that makes my life easier too, and which is how I want my clients to succeed, and similar, I think that's exactly what you want to do.
Oh, exactly. And that's why I often, calling you is never time wasted. It's always time well spent. So I do encourage people to do that. Thank you. Appreciate that. And listen, Peter, thank you so much for joining us on Fireway. I really appreciate it.
Thank you for having me, Stuart. It's a pleasure.
Oh, it's a good discussion. So now I'll take my turn to fire away. So I want to talk really briefly today about one of my pet peeves, and I guess I'm adding to the list every month here, but one of my pet peeves is I really want people to stop leaving employment issues to the very last minute when they're buying or selling a business, because as we talked about in season 7, episode 8 of Fire Away with Peter Cusimano, it's a critical issue. And I'll share a quick story. Many years ago now, probably about 10 years ago, I got a call from a law school friend, and this friend had gone on to practice corporate law in the States, and we kept in touch over the years, mostly talking about hockey. But he reached out to me, said he was helping with a client that was buying a business in Ontario. He told them they should talk to an employment lawyer, recommended me, wanted to see if I was available. I said, great. I was really excited. And then I asked him when the deal was closing. And he very, very sheepishly said, tomorrow. Now, at that point, I realized that we had missed the window. And as Peter and I talked about again in season 7, episode 8 of Fire Away, you always want to be proactive and you want to prevent the problem rather than trying to fix it later. At this point, the deal was done. It hadn't closed yet, but the deal was done. But even at that point, we were able to take some time. We were able to very quickly assess the HR situation, look at the contract, look at the employees. And we found a few ways to help our client. And then once the deal closed, we helped them put some contracts in place and mitigate their risks going forward. So it wasn't a complete loss, but it was a great example. If this was someone, and I should, in my friend's defense, he was new to the file. Apparently, the buyer had another lawyer. For whatever reason, the other lawyer disappeared on them. So my friend inherited this at the very last minute. So I won't blame him for this, but this is not unusual, where people are focused on whether they're buying or selling a business. They're focused on the purchase price. They're focused on the timing. They're focused on some other key issues, but they're not even thinking about the employees and what happens if they stay. What happens if they don't stay? What if I don't want them to stay? What if I buy the business and I decide I don't like them? What if I buy the business and, even though I was assuming that these core employees would run the business, they leave? all these things can and should be addressed while you're negotiating the deal. And as I often say, from a buyer perspective, you should negotiate with the seller. You should also negotiate with the staff and put contracts in place. There's a whole lot of things that can be done if it's done properly. The bottom line is that if you're buying or selling a business, you should never forget the fact that you're buying, or you're either becoming an employer or you're ceasing to be an employer. And either of those have significant legal implications and can have significant legal costs. So, and in many cases, you won't find out about that until it's too late. So I encourage everyone to watch season 7, episode 8 of Fire Away and my discussion with Peter Cusimano. We gave some great examples of what you should do, what will happen if you don't do things properly, including the costs, and make sure that when you're engaging in either, again, by buying or selling a business, make sure you've got a team. You should have a corporate lawyer. You should have an employment lawyer, their accountant, and anybody else that can give you the advice that you need so you don't miss anything. Bottom line, I'll say it now because I always like to say this. If you think you might need an employment lawyer, you probably do. That's a wrap for season 7, episode 8 of Fire Away. Our next episode is going to be airing on October 15th. I'm excited to be joined, first of all, by my colleague at Rudner Law, Nadia Zaman, and we're going to be talking with Alison Venditti of Moms at Work. So that should be a great conversation, October 15th. I want to thank you all for tuning in today. Very special thanks to Peter again for joining me. And as always, thanks to Rob, to Rebecca, and to Mark for helping put the show together. And I look forward to seeing you all next month. To quote one of my favorite hockey broadcasters, the pleasure was all ours.
At Rudner Law, we want people to treat their employment relationships as legal relationships and make informed decisions rather than assumptions. Keep up to date on Canadian employment law issues by following us on Twitter, Instagram, LinkedIn, and TikTok, liking our Facebook page, subscribing to our YouTube channel, and signing up for our newsletter. Past episodes can be found on YouTube, on our website, and archived on Facebook. And if you like our page or subscribe to our channel, you will receive notifications when the episodes are live. As we always say, none of that replaces legal advice tailored to your specific circumstances. If you think you might need an employment lawyer, you probably do. So please don't hesitate to reach out to us.